Hi everyone, welcome back to Keystone IAS Academy. Today we are going to see 4 very important articles from The Hindu newspaper, which are subordinate judiciary, anti-rape laws, UNESCO neurotechnology guidelines, and India-Africa relations. So today's first article talks about the lower judiciary crisis. Right now, India's district courts have 4.69 crore pending cases. That's almost the population of South Africa waiting for justice. And the Supreme Court has clearly said the problem is not only workload but stagnation in the subordinate judiciary, is what the article is saying. Okay. So here you can see the context, and it directly comes under the GS paper 2, judiciary, then polity, judiciary. Here is the practice question. Judiciary is a very important topic. So every year some judiciary related questions will come. Supreme Court or this time subordinate court pending cases are the issue which is mentioned in the article. So the questions may come. Yeah, coming to the article. So why is pendency increasing? So let's break it down. Judges in lower courts spend every morning doing clerical work, calling cases, issuing summons, taking or you can say marking attendance, all those things. Okay, these are the administrative work, means clerical work. So judges mostly in Supreme Court are doing this clerical work. So this eats up 2 to 3 hours daily. The real work, hearings, arguments, judgments get pushed to the afternoon. And coming to the second point, many new judges join without real courtroom experience. So earlier judges had 10 plus years as practicing lawyers. Now many join straight from exam, struggle with this workload. Okay, so this is why the spending is increasing. So some points are discussed in the article by the author. These points are very important, so we can write in the mains answer if the question comes. So first point is, what is the first point? Major work, clerical works are taking up in the morning, and afternoon only the hearings are coming up. Next, many new judges are joining directly from exam. They are struggling with the workload. Okay. Then examples where laws meant to reduce pendency made it worse. Okay, these are some examples where laws meant to reduce pendency கம்மி பண்றதுக்கு laws போட்டு which made it more worse. What are those? Pre-suit mediation in Commercial Courts Act. Businesses already send notices. Forced mediation wastes time. So 6-month cooling off in mutual divorce. Many couples want faster closure, so courts sometimes insist on waiting, cause false 1-year separation claims. New Rent Act confusion. No registered lease. Which court to go to? Civil, commercial, or not rent court? So multiple litigations are there. So CPC provisions like preliminary plus final degree. Why 2 degrees for partition? This creates years of delay. So all these cooling period and this mediation effect and confusion in some acts. So all these efforts which we made to reduce pendency sometimes create more worse than the real solution. This is what mentioned here. Okay, these are the some examples. Then simple reform proposed. There are some reform also proposed by the article itself. So these are the way forward. Yeah. Create one special judicial officer in every district court to handle calling cases, issuing summons, collecting written statements, recording ex parte evidence, preparing next day's list. So what it is mentioned is just allot a special judicial officer for doing this clerical works, so that this judging will not coincide with those work. So judges can finally focus on judging, not clerical course. This is what the article main point is. So other main points, some points what the article discussed is also what are the overview of this article, there are some structural issues which is overburdened the judges with the clerical works, then ministerial workload, etc. And there are some procedural issues. What is that procedural issues? Outdated CPC, multiple degrees, execution delays, etc. And some capacity issues. What are the capacity issues? Inexperienced judges, lack of training for those judges. And some reform is mentioned. What are those? Separate administrative codes, modernize CPC, and strengthen training. So these are the major points discussed in the article that I gave some overall view of the points whichever we discussed right now. So coming to the practice article, India's lower judiciary suffers from both structural and procedural inefficiencies that directly contribute to pendency. So discuss with examples and suggest reforms. It's a direct question. நம்ம இப்போ இவ்வளோ நேரம் என்ன பாயிண்ட்ஸ் எல்லாம் டிஸ்கஸ் பண்ணுமோ அதை டேரெக்டாக நீங்கள் வந்து இந்த ஆன்சரில் வந்து நீங்கள் யூஸ் பண்ணிக்கலாம். ஓகே. So coming to the second article, this article is very powerful and historically important. Why? The Chief Justice of India recently called the Supreme Court's 1979 Tukaram West State of Maharashtra Mathura rape case, which is famously called as acquittal and institutional embarrassment. So this moment revived discussions on how India's rape laws have evolved from a patriarchal understanding of consent to stronger survivor-centric protections built over decades through public outrage, landmark cases, and repeated criminal law amendments. The article traces the legal, social, and legislative journey from the Mathura rape case 1972, which happened to major reforms up to BNS 2023. So 1972 Mathura case linde BNS 2023 varakum these rape laws எப்படி வந்து நம்ம பப்ளிக்கோட அவுட்ரேஜ் மற்ற கேசஸ் ப்ரெஷர்ஸ் கிரிமினல் அமெண்ட்மெண்ட்ஸ் இந்த இதெல்லாம் வச்சு எப்படி வந்து எவால்வ் ஆயிருக்கு அப்படிங்கிறத வந்து இந்த ஆர்டிகல் ரொம்ப அழகாக எக்ஸ்பிளைன் பண்ணோம். ஸோ தீஸ் பாயிண்ட்ஸ் விச் we can directly use in mains article if so the question comes. And the syllabus la pathina GS paper 2 social justice and governments la irundhu governance directly it come. So here are the previous year question. Again same, National Commission for Women Related Issues edala irukudho adu eppadi tackle pandrathu adu here the second question also the same. We are witnessing increasing instances of sexual violence against women in the country. So directly the question was asked in 2014 in the point of view. Okay. Yeah, coming to the article. So in 1979 the Supreme Court acquitted two policemen who raped a 14-16-year-old tribal girl Mathura inside a police station. So they said it was consensual because she had no injury marks. So the Chief Justice today calls that judgment an institutional embarrassment. It's a very important point. So why this case was a turning point? So four academics wrote a famous letter to the Supreme Court. They explained the basic difference between consent is not equal to submission. So a scared or powerless girl may not resist. That doesn't mean she agreed, right? So consent is not equal to submission. So this letter, here you can see the four academicians' name. These four academicians wrote a public letter to Supreme Court which emphasized the difference between consent versus submission. So it's a very important. So what happened? Major reforms had triggered. Yeah, here we can see 1983 first criminal law amendment made. What has happened? Custodial rape made a separate offense. Burden of proof shifted from survivor to accused. This is a very important point. Then comes the 1997 Vishaka guidelines, which trigger, what is the trigger point of this Vishaka guidelines? Gang rape of Banwari Devi. So first workplace sexual harassment guidelines was framed after this, that is called as the 1997 Vishaka guidelines. Then again 2013 Nirbhaya amendments, next evolution. What happened in that Nirbhaya amendments? Broadened the definition of rape. So silence or weak no is not consent. Silent ah irukradho illa weak ah நம்ம இருக்குறாங்க weak ah வந்து no சொல்றதோ வந்து that doesn't mean it is consent. So அது consent இல்ல. Then age of consent should be above 18 தான் இருக்கணும். Mandatory FIR, free medical care, death penalty in extreme cases. So these are the Nirbhaya case க்கு அப்புறமா 2013ல வந்த amendments லாம் இதெல்லாம். Then 2018ல what are the amendments? என்ன கேஸ் வந்துச்சு? Huno Katwa. So அந்த கேஸ் தான் வந்துச்சு. அதுக்கப்புறம் வந்து amendments என்னன்னா death penalty for rape of child under 12, 20 years minimum for minors under 16, fast track investigation plus trial timelines. இதுதான் வந்துச்சு. That recent amendment or recent advancement சொல்லலாம் 2023ல BNS பாரதிய நியாய சங்கீதா. அதுல இன்னும் என்ன advancements பண்ணிருக்காங்க அப்படின்னா sexual offenses made gender neutral. This is what we are talked about in previous article also and in POCSO. So இப்போ எல்லா sexual offenses, POCSO acts, all these things எல்லாத்தையுமே எப்படி கொண்டு வராங்கன்னா gender neutral கொண்டு வராங்க. It not only against women or it not only against men, it can be against women also. அப்படி. So gang rape of women is less than 18. அப்படின்னா death or life sentence. New offense வந்து it will come under sex under false pretenses. New definition of sexual harassment was given in the BNS. Okay, so what are the overall main points வந்து we can conclude அப்படின்னா social movements, judicial failures, or then public outrage, all these are emerged, or all these are paved way for this legal reforms. That's why in the rape laws வந்து இவ்ளோ amendments ஆகி இவ்ளோ advancements இவ்ளோ வந்து amendments தாண்டி இப்போ வந்து ஒரு general neutral stageல வந்து நிக்குது. So that all these leads to the legal reform அப்படிங்கறத ஒரு இந்த article prove பண்ணுது. Also Mathura 1979, Nirbhaya 2012, BNS the 2023 லேந்து major shift என்ன அப்படின்னு பார்த்தோம்னா shift to survivor centric law. அந்த victim உடைய இதை வந்து சென்டர் பண்ணி சர்வைவர் உடைய சென்டர் பேஸ் பண்ணி அவங்களுடைய நலன் கருதி நிறைய லாஸ் வந்து அமெண்ட்மெண்ட் ஆகி வந்தது. அவங்களுக்கு வந்து ஃபேவரபிளா வந்திருக்கு. கன்சர்ன் நவ் டிஃபைன்ட் கிளியர்லி அண்ட் ப்ரோக்ரெசிவ்லி. அதுல மெயின் பாயிண்ட் என்ன, மூணாவது பாயிண்ட் என்னன்னா கன்சர்ன்னா எப்படி, வாட் இஸ் கன்சர்ன் அப்படிங்கறத வந்து கிளியர்லி இப்போ வந்து ஒரு எவல்யூஷன்குள்ளேயும் நம்ம வந்து டிஃபைன் பண்ணி வந்து ஜட்ஜஸ் வந்து ஒரு கேசஸ் அமெண்ட்மெண்ட்ஸ்லாம் கொண்டு வந்து இந்த பாயிண்ட்ல வந்து வச்சிருக்காங்க. ஸோ கன்சர்ன் இஸ் நாட் ஈக்குவல் டு submission is a very important point. Yet the same thing whichever I have mentioned is given here. You can just go through. Here is the latest judgment BNS, the latest reform, which is BNS 2023. Yes, here you can see the practice question. Again same, trace the trajectory of anti-rape laws in India from the Madura rape case, Tukaram versus State of Maharashtra 1979, to the BNS 2023. So you have to write it year by year, or just what are the amendments எப்படி வந்துச்சு. First 1979 என்ன ஒரு announcement கொடுத்தாங்க, next 19, which already see directly in the article, directly in the discussion. So what is the second question? How have social movements, judicial failures and public outrage shaped legislative reforms on sexual offenses? So as already the article என்ன major push பண்ணுது அப்படின்னா, it's not only the cases which came, நம்ம வந்து public outrage இருக்கு, social movements, judicial failures இருக்கு, நிறைய இடத்துல வந்து சரியான definitions கொடுக்காம இருக்கு. So all these things எல்லாம் எப்படி வந்து legal reforms-ஆ வந்து இப்போ மாறி நம்மளுக்கு BNS 2023 வந்து இருக்குது அப்படிங்கறத நம்ம வந்து டீடைலா எழுதணும். So please write this answer, practice writing this answer and post them in the Telegram group for review. Yeah, coming to the next article. UNESCO released the world's first global ethical framework on neurotechnology. So what is this neurotechnology? It's a new technology and is rapidly advancing through AI-driven brain-computer interfaces, implants like Neuralink, and neuroimaging techniques or neurotechnology. As you already know, neuro is the word which is connected to brain. So brain and computer is connected through AI. This global rise creates opportunities in medicine but also major ethical risks such as mind reading, behavioral manipulation, political misuse, discriminatory profiling and privacy violations. Definitely, if there is an advancement, there is a boon, there is a bane also for always for technology, right? So let's discuss here. So the UNESCO, what is this? UNESCO framework seeks to balance innovation with the protection of human dignity, mental privacy and freedom of thought. And this article will directly comes under GS paper 3 Science and Technology. You can quote as an example in any article also, in any mains answer also. Yes, coming to the article. So as I already mentioned, what is neurotechnology? Anything that reads or influences brain signals. For example, brain-computer interfaces like Neuralink, AI-based brain scans, implants to help paralyzed patients speak, devices predicting stroke risk, anything which is connecting to brain. So think of the brain as a radio station. Neurotech is the device that tunes into the frequency. Okay, see how interesting it is. So why do we need guidelines now? Because brain data can reveal political preferences, stress levels, hidden traits, decision patterns, all those things. So if misuse happens, it can include employee screening, insurance premium discrimination, political manipulation, targeted persuasions, all those things will happen. So these are the challenges, or these are the issues which will arise from this new technology. So let's see what UNESCO recommends. What is the principle that UNESCO recommends? Okay, the principles, the framework emphasizes human dignity, autonomy and free will, mental privacy, transparency, non-discrimination, protect children, elderly and disabled. So all these principles are very important to use neurotechnology is what the UNESCO guidelines mentioned. Also, UNESCO prohibits using brain data for manipulation, deceptive political messaging, commercial exploitation of neural signals. So if there is a new technology coming, then there will be some disadvantages also. So big institutions, UNESCO, UN, all this will definitely give guidelines on how to use this without harming human behavior, human dignity, all those things. So adukku enna guidelines, enna principle vandu oru neurotechnology use பண்றாங்க follow பண்ணனும், what the guidelines prohibits. So all these things நம்ம வந்து பார்த்தாச்சு. And mainly mention பண்ணிருக்கிறது strong emphasis on vulnerable groups, children, elderly and people with disabilities, that we all know. So it's a very easy article. And one important thing which is discussed here is open science versus IP debate. This we already saw in previous articles also. So what is this IP? Intellectual property versus open science. See, research மூலமா ஒரு technology advancement வருது, ஒரு idea வந்து வருது. So whether it should be keep it for openly for public, or அதுக்கு வந்து ஒரு subscription, or அதுக்கு வந்து ஒரு conditioning கொடுத்து அதை நம்ம வந்து safeguard பண்ணி வச்சுக்கணுமா? இது already the debate which are happening for all those research things. So here in the neurotechnology in the article in the point mention பண்ணிருக்காங்க. So what UNESCO wants open sharing of neurotech research like a public library. So neurotech research எல்லாம் வந்து open sharing வந்து public library மாதிரி நம்ம கொடுக்கணும். அப்போ அதாவது research பண்ணி அதில் find out பண்றது மட்டும் முக்கியம் கிடையாது. When you share those resources, அப்பதான் அடுத்தடுத்த innovations வருங்கிறது we already argued multiple times in the previous articles. So here in the neurotech also one point is included. What UNESCO wants here. Again same thing, open sharing of neurotech research like a public library, but innovation also relies on intellectual property, right? So that also very important. So countries must balance innovation with ethics. That is what UNESCO suggests. So what are the overall points we can conclude here is, what is neurotech? Neurotech of course definitely have high potential, but with also comes with a high risk. So UNESCO gives the first global ethical framework for this, and India must build neuro rights plus regulations soon, okay, while started using this technology for medicine or for treatments. Yeah, now coming to the practice question, neurotechnology offers unprecedented medical possibilities but raises equally profound ethical concerns. Whatever I said is, definitely it is giving the medical possibilities. It has high potential. Also it coming up with the high risk also. These are the ethical concerns. So how do we manage? So what are the guidelines are available? Here is the guideline. Analyze UNESCO's 2025 global guidelines on neurotechnology and discuss their relevance for India and what India should do if the technology, we are going to adapt this technology very soon. Okay, so please write the question. It's the direct points whichever we discussed in the article you can use here. So write them and post them in our Telegram group for review. Coming to the final article, it is related to foreign policy. The article reviews 10 years since the India-Africa Forum Summit of 2015, a landmark event where India invited all 54 African nations to Delhi. It evaluates India's diplomatic, economic, security, educational, and people-to-people progress with Africa, and highlights what next steps India must take to strengthen a rapidly transforming partnership as Africa becomes the world's youngest continent. So this article directly comes under GS paper 2, International Relations, India's Foreign Policy, etc. Yeah, here you can see the practice question related to international relation or India, Africa. It's a very common theme in. Yeah, now coming back to the article. Where we stand today. So since the 2015 India-Africa Forum Summit, India opened 70 new missions in Africa, trade crossed $100 billion, India's investment is equal to $75 billion, India pushed Africa's AU membership in G20, IIT Madras opened a campus in Zanzibar. So these are the advancement. These are the things which we did under this IAFS 2015. So it's been 10 years, right? Whatever we did for 10 years is very important. Please note this is a points which you can use in the mains answer while writing the India-Africa relations. So why Africa matters is very important question. Yes, by 2050, 1 in 4 humans will be African. India will be the world's 3rd largest economy. This is what the article is saying. So this creates a huge growth corridor. That's why we are focusing on Africa now. So what are the new areas of cooperation with the article or the author says is naval exercise, AKIMI naval exercise with 9 African navies. Where is that? Here it is. Africa-India key maritime engagement. That is what? AKIMI. So this is a naval exercise in 2015 with 9 African navies. Then ECOWAS credit line from Exim Bank, which is signal support for African-led development. Then UPI and digital public infrastructure can integrate with the CFTA's single digital market. So this is also UPI or integrating with the Africa's market. Okay, UPI is our India's market, integrating with the Africa's market. So these are the scope, these are the things which we are currently working now. Then people-to-people strength. What is that? 40,000 Africans trained in India. Many become ministers, policymakers, innovators, etc. So African athletes and students also contribute to India. So these are the advancements. These are the things which are working with Africa nowadays. So what India must do? What is the future or way forward? So connect finance to results. Build an India-Africa digital corridor. Revive the India-Africa Forum Summit. Okay, so here you can see connect finance to outcomes. So each credit line, credit line use must create a visible projects. Finance spend there should be some visibility of the results. Then build an India-Africa digital corridor. Again, already saw UPI, link UPI with the African public infrastructure, digital infrastructure or rupee infrastructure, all these things. Revive India-Africa Forum Summit. After 2015, in the summit so just again conduct summit every year or conduct a summit. So overall, what are the points discussed in this article? There is a shift from transactional to co-development partnership. Okay, this is what the main theme, which is transactional to co-development. Rendu country, India and Africa, rendu perume vandu நம்ம partnership பண்ணி ரெண்டு பேருக்குமே ஒரு growth இருக்கணும் அப்படிங்கற ஒரு aimக்கு நம்ம வந்திருக்கோம். So India's strength என்ன? Digital public goods, education, maritime security. So what is Africa's strength? Demography, emerging markets, innovation hubs. So இந்த ரெண்டும் இந்தியாவோட strength and Africaவோட strength ரெண்டையுமே club பண்ணி we should grow அப்படிங்கிறது தான் இந்த கோட் டெவலப்மெண்ட் பார்ட்னர்ஷிப்புங்கிற ஒரு தீம்க்கு வந்திருக்கிறோம். ஸோ இந்தியாவோட ஸ்ட்ரென்த் என்ன, ஆஃப்ரிக்காவோட ஸ்ட்ரென்த் என்ன, ரெண்டுமே செப்பரேட்டாக கொடுத்துருக்காங்க. ஸோ வி ஹாவ் டு merge or we have to collaboration பண்ணி we have to work for more advancement. Okay. Yeah, here is the practice question. India's partnership with Africa has matured from transactional engagement to a mutually beneficial development partnership. So critically examine in light of recent developments. Okay. Yes, before we wrap up, here is an announcement for all UPSC aspirants out there. So your free prelims test series is here. Keystone SPS, Sprint Prelims Simulator. So we are providing this for just 50 rupees as the registration fee. Rest of the test series will all be free. So you can enroll immediately. So you will get 45 full-length test GS and CSAT, both online and offline, one-to-one mentorship, then cash rewards for top aspirants, detailed explanations, all those things. Whatever UPSC aspirant required to clear prelims will available here. So you can confidently enroll now and call 730-577-541 for registration, or இந்த வீடியோல கொடுத்திருக்கிற லிங்க் டிஸ்கிரிப்ஷன்ல இருக்கும். So you can go through there, see the details of test series, and then you can fill the form there for registering this test series. Okay, so take the test, revise the key points, stay consistent. Your UPSC preparation grows 1% every single day. This is the key. So see you in the next session. Thank you.